Honorable Mr. Justice Jawad Hassan, distinguished speakers, respectful participants, good morning and Assalamu alaikum. When organizers of the event allocated me a topic, I found it very tricky and targeted, taking the domestic issues concerning arbitration in Pakistan. As we all know, the international investment regime is an increasingly powerful tool for spurring economic growth and stimulating global development. In Pakistan, the interaction of foreign commercial entities with local businesses is continuously increasing. The foreign direct investment inflow in Pakistan oscillated between 2 to 3.5 billion dollar since 2010, and the government has a target of achieving 7.4 billion dollar by 2023. In addition, Pakistan has 49 bilateral investment treaties, free trade agreements, including trade and investment framework agreement with United States and South Asian Free Trade Agreement with South Asian countries, and Afghanistan Transit Trade Agreement. Moreover, Pakistan has double taxation agreement with 51 countries. In the last decade, CPEC, being a linkage with Belt Road Initiative, has taken its root in the region, and emerging specialized economic zones, e-commerce business and digital currency are also flourishing, which increase the possibilities for commercial disputes. Amidst this vibrant business environment, the development of international commercial relations inevitably looks for efficient, expert and enforceable disputes resolution mechanism suitable for foreign as well as local parties. Primarily, commercial and investment disputes in Pakistan are chartered under the domestic legal regime, which has become archaic and burdened with complexities and challenges. Let us see how Pakistan legal framework has tried to meet the above challenges. There are 9 key legal instruments which regulate the commercial and trade disputes. Out of these, 3 laws, Contract Act, Specific Relief Act and Stamp Act were enacted in 19th century. And the other 6 laws, including Partnership Act, Sales of Goods Act, Limitation Act and Arbitration Registration Acts, came into force in pre-1947 era. Some of the substantial imbalances in these laws are that neither do they promote ADR or encourage parties to make it contractually binding as a means of settling disputes, no requirement of written contract and agreements, and no recognition of electronically made agreements too. And these laws do not provide for case management or pre-trial mediations, and nor the use of technologies in contract and legal and judicial process is encouraged and appreciated. These laws have not seen any major reforms since their enactment, so unable to match the pace of international developments in business and commercial transactions. We have ADR system at a very limited scale that includes the Arbitration Act 1940, the Foreign Awards Act 2011, the Arbitration International Investment Disputes Act 2011, Alternative Dispute Resolution Act 2017 and Punjab Commercial Courts Ordinance 2021. In a commercially world which is evolving very rapidly, it is a matter of concern that Pakistan, although a signatory to UNCITRAL, has not yet updated its domestic legal framework and could not synchronize its laws with the provisions of UNCITRAL model legislation. Resultantly, in Ease of Doing Business Report 2019, the World Bank ranked it at 157 out of 190 economies on the enforcing contracts indicator, which was based on time, cost and quality of judicial processes. The report noted that it took 1072 days on average for the resolution of a commercial disputes compared to 164 days on average in Singapore, 216 in New Zealand and 437 days in United Kingdom. As mentioned by the Honorable Chair, the judicial support on this issue rescued Pakistan. The very initiative of the Lahore High Court to establish commercial courts in Punjab helped to improve impression in the business community, and Pakistan ranking in the ease of doing business improved by 28 points, placing it at 108th position out of 119 countries. At the same time, Lahore High Court emphasized the need for a body of accessible legal rules for the successful conduct of trade, investment and business generally. Even the chair, in his famous Pizza Hut case, stressed the importance of commercial courts for efficient resolution of the disputes. There is a global movement to use ADR techniques for expeditious disposal of the commercial and business matters, such as in North America and Europe, mediation and judicial system is being introduced. In United States, ADR prior to litigation is mandatory. In Europe, the use of extrajudicial dispute resolution procedures and role of courts in mediation is encouraged. Likewise, in Africa, the mediation in commercial disputes is growing. The Asia-Pacific jurisdiction have proactively adopted UNCITRAL model and established Hong Kong International Arbitration Center and the Singapore International Arbitration Center, SIAC, which are leading the world in commercial and investment arbitration. The researchers have shown that promoting arbitration by ratifying the New York Convention increases FDI flow by 77% and international trade with convention members by 30%. While adopting the UNCITRAL model on international commercial arbitration, the trade has grown by 67% overall and 7% on the average. The initiative of establishing commercial courts in Punjab could not be institutionalized due to multiple factors, including structural features, antiquated legal and procedural framework. Therefore, the initiative of establishing commercial courts could not be adopted in the rest of the country. But let me share, by end of April 2020, there are 24,000 investment and commercial related cases which are pending in a regular courts, and there are about 41,000 cases which are pending in the special courts, which are the banking, commercial, insurance and customs. And let me share, there are about 4,000 cases of tax matter which are pending in the superior courts and the special bench of the tax department. These 4,000 are those cases which have been filed by the FBR. We don't have the account of those cases which are filed by the other parties against the FBR. Credibility of the processes and harmonization of the legal framework with rule of law values result in the expeditious disposal of the claims, which in turn are critical for uplifting commerce, trade and ease of doing business within the country. The issue with the existing ADR laws in Pakistan is that they are not harmonized with the UNCITRAL model law, and requisite rules, regulations, centers, experts and panelists have not been notified yet. Besides revamping and harmonizing the existing legal ADR framework in line with the rules and practices established by the International Center for the Settlement of this Investment Dispute, the United Nations Commission on International Trade Law and the International Chamber of Commerce and other such forums, the dedicated commercial courts to provide swift, affordable and enforceable disputes resolutions are required to be established to respond to the rapidly changing business dynamics and disputes across the country. It is universally acknowledged that the purpose of the modern commercial code is to provide an efficient and credible means of commercial dispute resolution, particularly in relation to the international disputes, with the aim of attracting investment. It will not be out of question to mention that cognizant of this fact, the Law and Justice Commission of Pakistan has always highlighted the importance and the need of ADR in in its annual judicial conference, and it was due to these efforts we have in country the ADR Alternative Dispute Resolution Act for Islamabad. We have Punjab Alternate Dispute Resolution for Punjab, Khyber Pakhtunkhwa Alternate Dispute Resolution, and the Code of Civil Procedure for the Sindh government. Not only this, during the pandemic, the Law and Justice Commission organized online training program for judges of the superior courts and the district judiciary with tie-ups and Singapore Judicial College on ADR. And now, under the auspices of Honorable Chairman Chief Justice of Pakistan, the LGPCP has taken the initiative to operationalize the newly enacted ADR laws by framing rules, notification of ADR centers, and notification of the experts and panelists. And LGCP is very much happy and willing to extend all its cooperation for establishment of any dispute resolution center based on global best practices to make Pakistan hub of commercial and investment arbitration. Thank you very much.